Hi, everyone, and welcome to Himal podcast. I'm Raisa Wickrematunge. In recent months, there has been increased discussion around regulating content online. For example, Pakistan recently enforced its removal and blocking of unlawful online content rules, giving the state regulator broad powers to restrict online content. India recently brought online news portals and entertainment content providers such as Netflix under its purview, and Sri Lanka has announced its intention of formulating laws modeled on Singapore's rules governing online digital content. Given the discussion around regulation in the region, we thought it fitting to have a conversation on the topic of regulation. Is it necessary? And if so, when should it be introduced? I'm here to discuss this with Dr. V. Sridhar, professor at the Center for IT and Public Policy at the International Institute of Information Technology in Bangalore and author of Emerging ICT Policies and Regulations, Roadmap to Digital Economies. Welcome to Himal podcast, Dr. Sridhar.
Thank you very much. Thanks, Raisa, for having me in this particular edition.
So, just to start off, in your book, you seem to have taken the position that digital regulation is almost inevitable. Very often, though, the state regulates the digital realm not to fix the market, but for authoritarian reasons and for the suppression of freedoms. In this context, who do you think the regulator should be given these realities?
Telecom, as such, has been in a regulated industry all over the world for quite some time. Right? So the regulator normally uses command and control mechanisms to control, for example, the telecom industry. The reason is that telecom industry, a telecom marketplace, is not a competitive market. It is an imperfect market with about 3 to 4, maximum 5 telecom operators providing service, and therefore it is an oligopoly, and all the imperfections of oligopoly will be present in the telecom market, and hence the need for a regulator. Now, if you move towards the digital space, right, internet companies, digital platforms, over-the-top players, and so on, we have not seen active regulation all over the world for quite some time until recently. The reason is that this is a new area of technology. There are innovative services that are being provided by the various service providers, and therefore we should encourage innovation. Right now, only after it reaches a certain point where the imperfections of the market start exhibiting, that the regulators step in. I mean, the cornerstone of regulators stepping in is through Facebook Cambridge Analytica deal, or, for example, Snowden's revelation. Right? So these things have prompted the regulators to put in some rules so that the consumer benefits are not affected. So I would say that the regulators have a role to play in the digital space, but not so much as the telecom regulation in the traditional sense. So, in the book also I advocate, for example, self-regulation, co-regulation, or the methods by which the digital space could be sort of regulated, and not in a very strict command and control mechanism by the state.
Your book frames regulation as primarily a necessity in the context of imperfect markets, as you mentioned. Lack of competition, high barriers to entry, and so on. Do you think a purely market view is sufficient to understand digital regulations?
That's a good question, Reza. So it is still evolving, right? Suppose if, there has to be a yardstick to find out when the particular industry has to be regulated or it should not be regulated. Now, the yardstick that we normally use are the general principles of imperfectness in the market, right? So that is from the economy's point of view. There can be a different views from the other areas. For example, if you look at the societal point of view, maybe the economic point of view of regulation may not be perfect, right? But at least the telecom regulation, as of now, always looks at some imperfections in the market. For example, in the internet space, right? So, for example, Google or Amazon, they have become monopoly behemoths, and therefore there is a reason for the regulator to worry about it, because it is an imperfect. It has turned out to be an imperfect market, right? So the traditional view of regulators is to look at imperfectness in the market and then take appropriate actions if imperfectness, um, you know, uh, are present. Now, it is possible that that may not be the ideal way to look at it. Like, for example, from the societal point of view, even if there is a perfect market, for example, in news, for example, we have so many OTTs to providing news, but still there can be imperfection because there can be fake news which can be propagated. It may not be of, it may be of reducing value for the society at large, and therefore the regulators might have to come in and then take some necessary actions.
So I wanted to touch on events that have recently made the news, which is India's kind of move to ban China-based apps, including, the very popular app TikTok. And this has had a negative impact on the emerging digital content creator market. What is your view of this move?
Yeah, so that's a good point, Raisa. So, I discuss in one chapter about even the privacy chapter a little bit because I have done a lot of work on this, later on, after writing the book. This is called the data nationalism, right? So once, we thought that, free borders, open countries, it is good for the benefit, it will, have positive impact on trade, especially digital trade. But as of now, most of the countries seem to be creating policies which protect their national interest, right? So the national sovereignty has taken precedence in most of the cases. So data localization rules have come in, right? Most of the countries have data. Even in EU GDPR, there are adequacy rules which want to, confine the data within the limits of EU to as much as possible. So most of the countries have started enacting these rules, which are very nationalistic in nature, right? Now, see these data national policies, data protection regulation, which prevent certain apps to be used, which prevent data to be transferred across borders, right? Which want all the data to be stored within the country by even global, internet, service providers. No, that is not good, right? So there are again, what I'm saying is, if we say that all data, all digital data about the citizens of the country have to be stored within the country, if we make a rule like that, then it is not going to fly, right? Because see, on one hand, there are a lot of economies of scale of storing digital data in the clouds, right? So the cloud may be anywhere. It improves reliability, it improves security. So it is in the interest of the data fiduciaries to store data in a disparate location so that the availability of the data is as high as possible, right? But for for nations might say that this particular data is, for example, if you take India's data protection, draft data protection rule, it says that there is a set of data which is very particular, it's very sensitive, and therefore it needs to be stored within the country for for example, security, national security purposes, or preventing fraud, for example. No, that is possible, but we need to clearly subset the data that needs data localization for a purpose, right? So it is very, very important for the state to define the purpose behind data localization. What is the purpose? If, for example, data security, surveillance is the purpose, then only that data which enables surveillance should be stored, right? Now, ideally, that should not be the case. In fact, bilateral agreements and global multilateral agreements have to take place so that even if the data is elsewhere, we should be in a position to access it, right? The state should be in a position to access it given the purpose. So I find that in most of the data regulations, the purpose is very ambiguous, right? The purpose is very generic. We need careful deliberation on what is the data that needs to be stored locally and for which purpose, so that it can be clearly articulated in the policies and also can be enforced.
And do you think this is something that the state should be doing, given, the concerns we were talking about earlier as well, where, there have been this tendency to use it to kind of suppress freedoms?
Yes, definitely, definitely, right? For example, the internet shutdowns, which have been happening all over the world, especially in countries like India, that is not good, right? Because as you know, I am teaching courses online, and there are students who have to access my course, in real time, synchronous. I'm giving a talk, but unfortunately, because of the lack of 3G or 4G, because of data, internet not being available, because of shutdowns, internet shutdowns, they are not able to access my course, and that is, who is benefiting? Nobody is benefiting. Actually, the students are suffering, because of that. So blanket shutdowns, right, like this do not serve any purpose. Similarly, I'm saying that, any regulation, the blanket regulations such as, store all data locally, ban all the apps. I mean, these are not the way in which the policies and regulations should be pronounced. It should be there should be a very articulated purpose, and there should be a timeliness involved. For example, internet shutdown in some of the states in India have been going on for a long time. I'm against that because has the purpose been satisfied? Then why not open it? So there has to be a time limitation, right, on any aspects that we are dealing with respect to stringent regulations such as internet shutdowns or data localization and so on. Right? So I'm saying that the states have to be conscious about this. Who is benefiting from all these things, right? Okay, I want to shut down because of certain purpose, and after the purpose is achieved, then I should open it up.
I also wanted to talk a little bit about some of the other topics you've covered in your book. In light of, for example, recently in South Asia, internet service providers have been tying certain digital products with their data offers. And
Right.
this is especially happening, in this age of where there's a lot of remote work and study due to the pandemic. So, for example, special packages for Microsoft Teams, even for things like Netflix and so on. In light of this, what do you think this means for net neutrality?
As you know, there is pure net neutrality, right, which means that the content and the users should not be differentiated. I mean, it should not be discriminated. That is pure net neutrality. Pure net neutrality with respect to price, traffic, and users. I mean, there should not be any discrimination. Then there is pure non-net neutrality, where you can differentiate. You can differentiate with respect to price. You can also differentiate with respect to the traffic, so that the priorities can be provided for Netflix, for example, or the users themselves. For example, Netflix users are given more speed, and things like that, right? So there is absolute discrimination. Now, most of the countries, right, we don't fall into pure net neutrality or pure non-net neutrality, but we fall sometimes in between. For example, there can be a zero rating package, right? So, for example, if you subscribe to Netflix plus, for example, a telco's, 4G contract service, then you might get it for free. But if you access any package other than what is bundled in that particular offer, you might be charged, right? So that is price discrimination, right? Price discrimination across different content, right? The content which is bundled is given free of bandwidth cost, whereas the other one is priced at a positive price. Right? And therefore, the users will tend to consume more of the zero priced offering. For example, the content that is bundled with the service compared to the others, and therefore the others will die, right? That's the concept of net neutrality. So I am not totally against, for example, certain kinds of non-neutral behavior, non-net neutral behavior, right? So, for example, if the content is bundled with the service provisioning, as long as the user has the option for choosing some other content, right? If he or she is interested, and if it is allowed, then it is okay, right? We can tolerate, right? Especially in developing countries, for example, it may be the case. For example, Africa. You take Africa, most of the free basic services are available. Free basics of Facebook are available in most of the African countries. So they have taken a stance saying that, with free basics, I'm getting all these Facebook content free with the service contract, and therefore it is going to benefit the masses at large, and therefore we should allow it, right? India has taken an absolutely net neutral stand, pure net neutrality stand. India it was not allowed. US has gone back and forth, right? So these things do happen. So the countries have to be very clear, right? When they are making regulation. So, for example, if we want small and innovative entrepreneurs to compete with the giants such as Facebook and Google, then we should not allow bundling, right? Bundling of the application with, for example, the service provider at zero price, right? Zero price. Right? So if it is positive price, if that the other application is also available at a slightly higher price, then it is okay. It's not a complete violation of net neutrality. So the rules and regulations have to be formed taking into consideration the ecosystem that we want to nurture. See, we want to nurture innovation and we want to nurture local startups competing with global startups. Then we might want to move more towards net neutrality compared to, for example, the non-net neutrality point of view, right? So that is the trade-off or the balancing walk that the regulators have to do.
What would your kind of advice be to South Asian digital rights activists as they get ready to face a string of stringent state regulations that could negatively impact freedom of expression?
Right. So definitely see, all these aspects, right? For example, data localization or, you know, states' rules on curbing freedom of speech on the digital space is, it has been bothering, all the data subjects at large. So, as you know, in the in Egypt, when there was the rising was there. So people, there was an internet shutdown, and the people within Egypt are not able to communicate outside. So, and the same thing may be happening in China because of the Chinese firewall that they have created. So, the states have to allow, freedom of expression, right? And digital space, because of the ease with which we can communicate, we can reach out to larger, masses. It should not be stifled, right? But at the same time, the government should carefully note, for example, the speech or the content that if it creates some social unrest, then appropriate actions may be taken. For example, there is a lot of talk about intermediaries, right? So Facebook and WhatsApp and so on. I mean, are they liable for the information that is carried? Should they be controlled so that they will be able to proactively monitor the content and then take appropriate actions if it is found to be negative for the society at large? So I'm against proactive monitoring, right? But the intermediaries should be liable. Suppose, for example, if there is a hate speech and the intermediary comes to know about hate speech, then they should take some actions. They should take some actions in order to filter out hate speech, notify the users that there's such a kind of things is happening. I mean, those are some things that the intermediaries have to take action on. I don't know about the other countries, other South Asian countries, but in India, for example, there is absolute immunity to the intermediaries, right? So intermediaries are intermediaries, and therefore they should not, they are not immune. They are immune to, for example, the content that is going on through the network. So they have to be made liable. They have to be made responsible because they affect society at large, and therefore there has to be some amendments to the way in which the intermediaries have to function, so that the negative aspects of the free speech, for example, hate speech or misinformation and things like that, can be controlled to some extent.
You also said that the state should take appropriate action given there are instances where there's social unrest. Are you confident that the state, in this example, I guess we'll talk about the Indian state, are you confident that the state will be able to kind of define what action is appropriate?
See, definitely. I mean, Raisa, most of the South Asian nations, right, including the large countries such as India, have do not have enough capacity in the government to make appropriate regulations and rules in a perfect way, right? So uh, we normally, I mean, we it is quite possible that we might actually take rules and regulations from other countries, and we might, for example, most of the countries have adopted GDPR because that has become a golden standard. But when we try to enforce it, it becomes a problem. One of the things that we have noted in most of the countries is that the state is not liable for their action. You know, Individual data fiduciaries are responsible, but what about the state if it makes a mistake, right? And they should be made liable, right? So that is totally missing in most of the developing countries, right? Because it is all state driven, right? So state can ask, given certain purpose, but if it is misused, who is liable? The state has to be made liable, right, and responsible. And that's one of the things we in India are, requesting it to be included in the data protection bill, right? Because there are a lot of instances where the government or the state has gone wrong, right? They've intruded the privacy, they have intruded certain aspects of free speech, and if they are held liable, so today the only recourse that we can take is the judiciary, right? So apart from the judiciary, there is no way by which the government can be made accountable for if they take wrong actions. But it has to be embedded. I think to some extent EU GDPR has succeeded in embedding the government as one of the data fiduciaries and be made responsible and liable for any misappropriation and misconduct. And that has to be included in the regulation of most of the countries. Then we don't have to really go to the judiciary for each and every event, right? We can possibly solve it using the existing regulations and rules.
Right, that leads nicely to my next question, actually, which was on data protection legislation, which is a topic of discussion in Sri Lanka because we are also contemplating, passing legislation on data protection. And India did produce this data protection bill in Parliament in 2019. Broadly, can legislation on data protection always be a panacea to kind of privacy-related issues?
That's a good question, Reza, right? So laws and legal, rules and regulations are there so that the, the stakeholders in the ecosystem conduct their behavior properly, right? So we assume that if there are rules and regulations, then they will comply to that. But that's not the case, right? Even if you take EU GDPR, there are so many violations. In fact, I teach a course on privacy, and we have found that, the cookie law, the famous cookie law in the EU has been violated left and right by all the data fiduciaries, right? Now you can ask this question, given the rules and regulations, why are the data fiduciaries violating this? And are they not being caught? I mean, if they are caught, what will be the liability for them, right? Now, European Union to some extent has succeeded, right? So they have put a very high penalty for violation of privacy, for privacy breaches, right? Notification. If they don't notify privacy breach, it's going to be like, $10 million and then 2% of the annual gross revenue, global gross revenue. And if, for example, data fiduciaries do not take due diligence and security and protection of the privacy of the individuals, then it is much more, right? It's 4% of the annual gross revenue of the data fiduciary and so on. So there is a high liability, high penalty if you violate, right? On the other hand, most of the other countries do not have. For example, even in the personal data protection bill, we have copied to some extent the EU GDPR, but still, whether someone will be caught if they violate the rules and regulations, and if so, will the penalty be applicable? Will the data fiduciary which is violated will pay that particular penalty or get away with it? Right? These are all big question marks. In most of the developed countries, that is the problem. Law is written, rules are done, regulations is there, but the enforcement of the laws and regulations is very weak, right? And that is one thing that I want to stress upon with respect to data protection. So we might come up with, Sri Lanka can come up with an excellent data protection regulation, but is it going to be enforced? Is it going to be, if, for example, somebody is found violating, is it going to be penalized? The data fiduciary is going to be penalized by how much and so on. So, data fiduciaries, as you know, they want to, they will look at the cost and benefits, cost of compliance versus the benefit of not complying, right? So if the cost of compliance is lower compared to, for example, the benefits of breaching the law, then they will do that. And that has been the way in which, for example, the Facebook Cambridge Analytica deal came up, right? So the benefits seem to have been larger, and therefore they breached that particular rule, right? And so what I'm saying is that these data protection regulations provide the grounds, the reference range, right? And it is for the data fiduciaries and all the other stakeholders to comply with it. But if they don't comply with it, the state has to take stringent actions, enforce it. And that is the way in which this can go on. So to answer your first question, is data protection regulation a panacea? No, it provides a ground rule, right? And the question is whether we can enforce whatever is present in the data protection regulation, not only for private data fiduciaries, but also for government data fiduciaries, is a question that needs to be answered by most of the developing countries.
And yeah, for the record, I think you did already mention in passing that you felt that India's data protection legislation was kind of imperfect. But just wanted to ask if you wanted to add anything to what you mentioned
Yes.
earlier.
So a couple of things, right? So a couple of things. So for example, it mentions that the critical personal data has to be stored within India and India only. That is one of the clauses for data localization. Now, it has left the state to define what critical personal data is, right? And therefore, it is an open question. So it can come up with anything, and everything under the sun later on. The second one is the definition, the definition of personal sensitive data, which has to have at least one copy within India. A mirror copy has to be there within the jurisdiction of the country. Now, again, it is very loose. Passwords, things like that have been included in the sensitive personal data. So these definitions are a little bit loose, but nevertheless, it is a move in the right direction, right? Because it provides the ground rules for data fiduciaries to do data protection when they collect, process personal information, right? So it's a good start. It's a good start, but it has a little bit of and as I've told you before, the government fiduciaries are not included in the, for example, the set of entities that has to comply with all the rules and regulations of the data protection bill and the act when it is enacted. So inclusion of government as one of the important data fiduciaries, is very important in the success of any data protection bills and regulations. Otherwise, as you have correctly stated, state can actually, because of the power asymmetry between data, government and citizens, it is possible that the government can actually, do things which are beyond the rules and regulations which are defined in the policies and regulations.
You also speak of artificial intelligence as a double-edged sword in your book. Why do you say that? And what do you think can be done to mitigate the negative impacts, including, for example, on the labor market?
So as we have seen, right, the machine intelligence is taking over. It has come into the market, and a lot of routine tasks are being automated. Today, because of the computational power and the intelligence of the algorithms and the availability of large amount of data, that even non-routine tasks, cognitive tasks, are also getting automated. So it will have definitely an effect on the labor market, right? So, for example, already we are seeing that some of the routine jobs are being taken over by machines. For example, even in the IT industry, if you take IT industry, it is supposed to be a highly cognitive, task-oriented industry, but the testing jobs are gone, right? Because most of the software testing is being done today by robots and algorithms, and therefore it will have an effect on the labor market. But the important thing, I think, Professor Asimilgu of MIT has, excellent, done an excellent analysis on the impact of the labor market. So, if, for example, if there is going to be an impact, whether it is in the routine, labor-oriented tasks or the non-routine cognitive tasks, the machines are going to take over. Then the problem, the challenge for the government is to do skilling appropriately, right? And then define where the machines should go and where the machine should not go, right? So, for example, if labor intensive work is very important for example, for a particular country, then they should encourage AI and machine intelligence to be used more for cognitive tasks, non-routine tasks. Something like that should come into picture. So, but in general, the impact of the artificial intelligence and machine intelligence on labor market is the question of reskilling, right? So we need to really reskill our labor force because we cannot stop technology from progressing. We cannot artificially stop it, right? If it comes to a stop on its own, it's fine, right? So any company will either recruit a machine to do a particular job or a labor to do a particular job based upon the productivity, right? Marginal productivity to wage. So if, for example, the marginal productivity is higher compared to the wage, then they will deploy, for example, labor. If, for example, it is cheaper and more productive to deploy machine, they will deploy machine. So it's all economics, right? So in order for us to carve out a space for ourselves, we need to be very clear as to reskill, right? So the humans, if humans become better than machines, then they will never be replaced, right? Both in terms of wages that we pay and also based upon the productivity, right? So if the labor becomes more productive at relatively lesser wages, then they will not be replaced. So there's no need to worry, right? So I would really advise, as is given in the book, to encourage the positive aspects, right? And then mitigate the negative aspects. The negative aspects can be mitigated using regulation, right? So for example, trustworthiness. Whenever I employ machine intelligence or a robotic system, it has to be trustworthy. EU guidelines have come out with respect to, the mission, the autonomous system regulation, and we should take some clue in order to incorporate it in most of the countries.
So thank you so much for joining us today.
Thank you very much.